Okay. The House Select Committee on Discipline will come to order. We have a replacement letter from Leader Cross. Representative David Harris will be here today instead of Sid Mathias. Clerk, please call the roll.
Curry.
Here.
Rose.
Yes.
Acevedo. Here. Conley. Here. Dubuclet.
Present.
Harris. Here. Kozel. Here. Lilly.
Present.
David Harris.
Here.
Nybo. Riley. Here. Sosnowski.
Here.
Not only a quorum, but a full complement. And the chair would note that Representative Derrick Smith is not here today, but his attorney, Mr. Henderson, is present. Mr. Henderson, could you confirm for us that you will serve as counsel for Representative Smith before this committee?
Yes, so confirmed.
Thank you very much. The Select Committee on Discipline is created pursuant to House Rule 94, following a report of the House Special Investigating Committee that thought there were reasonable grounds to bring a charge for formal disciplinary action against Representative Derrick Smith. That committee appointed Representatives Lou Lang and Jim Durkin to present the case for disciplinary action before this Select Committee. I acknowledge the presence of the two House managers, and I would ask at this time that you would formally present the charge and specifications against Representative Smith.
Thank you, Madam Chair. Representative Jim Durkin from the Minority Caucus. On June 5, 2012, the Special Investigative Committee of the Illinois House found reasonable grounds exist to bring a charge with specifications for formal disciplinary action against State Representative Derrick Smith of the 10th District. That charge and specification reads as follows. Charge: Representative Derrick Smith abused the power of his office by participating in a scheme to obtain a personal benefit in exchange for his official acts. The specifications are as follows. Representative Smith, in his official capacity as a state representative, has an obligation to faithfully discharge his duties in the best interest of the people of the state of Illinois and not for his own benefit. During the time period beginning on or about December 2011 through March 2012, Representative Smith agreed that in exchange for a cash bribe, he would provide an official letter of support for a daycare's early childhood construction grant to the Illinois Capital Development Board. On or about March 1, 2012, Representative Smith did in fact sign this official letter of support in his official capacity as a state representative and planned or intended for that letter to be submitted to the Illinois Capital Development Board. On or about March 10, 2012, Representative Smith did in fact receive a cash bribe in exchange for providing this official letter of support. Accepting a cash bribe in exchange for an official act, or even plotting or attempting to do so, constitutes a breach of Representative Smith's obligation as a public official to faithfully discharge his duties in the best interests of the people of the state of Illinois and warrants disciplinary action by the House of Representatives. It is our intention, myself and Representative Lang's intention, to work cooperatively with counsel for Representative Smith, as Counsel Victor Henderson, on matters of evidence and procedure, and we ask the same of him. Representative Lang and I will stand ready to answer any questions at the appropriate time. Thank you.
Thank you very much. Mr. Henderson, do you plan for your client to contest the charges or to admit to them?
The charges are contested.
Thank you very much. All right, unless there's objection, I'll enter into the record the report of the Special Investigating Committee as Select Committee on Discipline Exhibit 1. Any objection? Thank you. It will then be part of the record. So with the formalities aside, I'd like to make a few opening remarks. This is not a happy day for anyone. We are brought together because one of our members has been accused by federal prosecutors of a crime that, if true, is a breach of the public trust, a trust members of the Illinois House of Representatives have sworn to uphold. We are brought together because the Special Investigating Committee, after gathering whatever evidence it could, concluded there was a reasonable basis for bringing a disciplinary charge against Representative Smith. It's our job to listen carefully to the evidence, to remain open-minded as we do so, and we must work hard to reach a conclusion that is correct and is also just. It's important to understand that we are not an investigative body. The primary investigation and fact-gathering function was undertaken by the Special Investigating Committee, and while this Select Committee is able to consider any additional information that comes forward, our primary responsibility is to sit as an impartial jury and judge the evidence and the arguments put forth by each party. I would also remind everyone that this Select Committee is not the final word on this issue. The role of the Select Committee on Discipline is to make a recommendation to the full House, either to exonerate Representative Smith or find him at fault and then recommend a specific penalty. The final decision lies with the full House of Representatives. The process needs to be fair to both parties, and it needs to be orderly. I will exercise my authority under the House rules to establish procedural rules for this committee. I expect to have those rules filed with the clerk in very short order, and all parties will be provided a copy. Finally, I want to emphasize to both the House managers and Mr. Henderson that stipulations of fact or evidence is strongly encouraged both by the House rules and by me. We hope that in lieu of a protracted battle over documents or other evidence, the parties could reach agreement and so stipulate. Representative Rose, I would be happy to turn the chair over to you for further comments.
Thank you, Madam Majority Leader. The Select Committee on Discipline has a weighty responsibility to fairly, deliberately, and impartially conduct proceedings related to the charge and specifications brought forth by our colleagues on the Special Investigating Committee against Representative Derrick Smith. I believe that it is fair to say that we will commit to being very deliberate in our consideration of the charge and specifications and in our evaluation of the information presented by the managers. The role of this committee is directly linked to the Illinois Constitution. Article 4, Section 6D grants the Illinois House the authority to determine the qualifications of its members. After the Special Investigatory Committee found a reasonable basis for bringing these disciplinary charges, our committee was formed pursuant to House rule. As the Majority Leader noted, we are not an investigatory body, nor, I would point out, a court of law. We are an internal body of the House that is here to review the charge and information presented by the House managers and by Representative Smith or his attorney. To restate and conclude, we will strive to conduct ourselves in this proceeding in a manner befitting the seriousness of the charge, pursuant to the rules that I believe, as the Majority Leader just indicated, will be established shortly, and conclude as expeditiously as possible. Thank you.
Thank you, Representative Rose. Anybody else like to add any comments at this point? If not, then the next order of business is our role in relation to the role of the United States Attorney for the Northern District of Illinois and his ongoing federal investigation about Representative Smith and any related areas. This is a road down which some of us have traveled before. During the House impeachment investigation of former Governor Blagojevich, that committee decided as a body that it would respect the directives of the United States Attorney with respect to any information he was willing to turn over to the committee and any independent investigation that the committee undertook to gather information. Simply put, that impeachment committee agreed not to look for additional information or consider any evidence that the United States Attorney thought would jeopardize his ongoing federal investigation into Governor Blagojevich and related matters. At the impeachment trial of former Governor Blagojevich before the Illinois Senate adopted the same rule as part of its procedural rules. The Senate ruled out of order any evidence or testimony of any kind if the United States Attorney deemed it to be in interference with his ongoing federal investigation. Our Special Investigating Committee, empaneled this year to consider the evidence against Representative Smith, adopted the same rule. Written documentation of the U.S. Attorney's position was entered into the Special Investigating Committee record as Exhibits 6 and 7 taken together. Finally, I would note that the court overseeing the federal prosecution of Representative Smith has entered a protective order that essentially seals from public view the evidence provided by the U.S. Attorney to Representative Smith. Unless there is any objection, I would plan to enter into the record a copy of that protective order as Select Committee Exhibit 2. Any objection? Hearing none, we will do exactly that. Given this long line of precedent, and in fact it's a precedent with which I agree, I would suggest that this committee follow this lead and adhere to the directives of the United States Attorney. Stated simply, the committee will refrain from pursuing or hearing any evidence that, in the opinion of the U.S. Attorney, would interfere with his pending case or his ongoing investigation of Representative Smith. Representative Rose, do you so move?
I do.
So Representative Rose so moves. Is there any discussion? Hearing none, clerk, please take the roll.
Curry.
Aye.
Rose.
Yes.
Acevedo. Connolly. Dubuclet. Greg Harris. Kozel. Lilly. David Harris.
Yes.
Nybo. Riley. Sosnowski.
Aye.
On a vote of 12 yes, a unanimous vote, the motion is adopted. So our final issue today is scheduling. The scheduling of the final hearing and any interim dates. I'd like each side, the House managers and Mr. Robinson, to provide the committee with some idea as to how much time they believe they will need before the final hearing. And I'd ask the parties to keep in mind that the principal investigative work has already taken place under the Special Investigating Committee. So first, may we hear from the House managers on the scheduling issue.
Madam Chairman, ladies and gentlemen of the committee, the House managers believe we can put into the chairman's hands or to Mr. Ellis's hands as the attorney for the committee all the information the committee would want from us by the end of business this Friday.
And I'm sorry, I apologize, Mr. Henderson. I called you Mr. Robinson, but I'll call you Mr. Henderson now and ask you please to give us your sense of the timetable.
Well, if the chairwoman would indulge me for a more extensive response.
The chair will, but not very extensive, because
Okay.
you will have every opportunity to deal with the substantive issues when we come to that point in our proceedings. So really, scheduling is the issue.
Well, in response there, and I'm going to echo some of the words that were used by both the chairwoman and some of the other members in terms of fair, which is in the record, evidence, and being deliberate. And it is painful sometimes to be honest, but it is also important to be honest, because that's why we're here from a democratic standpoint. It's impossible to be fair and to be deliberate and to hear evidence and to do these things by Friday. As you know, the representative has been vigorous in asking the judge in this matter to release all information. The U.S. Attorney has vigorously fought releasing information, and from the representative's perspective, you cannot have a fair and deliberate process that will result in the right income anytime soon. I don't want to put a date on it. I certainly would think that, and clearly, and again, I also have to, make this clear for the record, that if there is an attempt to expedite the process prior to the time of the November elections, then that undermines any attempt to present the proceeding as being one that's being fair or deliberate. So with that statement, again, I don't perceive that the information can move, or that this process can move that quickly, even with the submission of evidence, as the House manager suggests, by Friday.
Madam Chairman,
Representative Lang.
I would respond to Mr. Henderson by saying that there were motions in federal district court relative to the protective order. The judge has ruled on that protective order. The people of the state of Illinois and the integrity of the House of Representatives demands that we move on this fairly but expeditiously. The election should not have anything whatsoever to do with the final decision of this committee, nor with our schedule, because we're here to seek a just result, but we're here to seek it on behalf of the taxpayers and the citizens of our state, who demand and expect that the members of the House of Representatives act every day for the people of the state of Illinois with integrity. And one of the things this committee will determine is to whether Mr. Smith has conducted himself that way. And so we can be ready, we will be ready by Friday to provide to the committee all the information the committee seeks as to where we're going in this matter, what witnesses we will call, if any, what documents we will provide, if any. We're prepared. This matter has been before this committee. While the committee has not convened, it's almost 30 days since the committee was formed. There was a former committee, the one chaired by Representative Nekritz, that provided the impetus for this committee. And so I think Mr. Henderson and Representative Smith are both well apprised of the charges, well apprised of the case, and it seems to me that they should be ready to proceed.
Thank you very much. Do members of the committee have questions? Oh, I'm sorry, Mr. Henderson.
Yes, I'd like to correct the record so all of the members understand what the judge's protective order means. In effect, there is evidence that Representative Smith does not yet have access to. The government provided quite a bit of information to Representative Smith just a day or two ago, within the past 24 to 48 hours. That's A. B, what the protective order requires is that each and every time the representative would like to get information to make available to you, that the representative is required to go and ask the judge for permission. So it's not the prosecutor's office that determines whether or not Representative Smith gets to take information that would exonerate him and present it to you. Rather, it's the judge that makes that determination. And so that process is one that's ongoing, and so each and every time there's information that we want of the thousands, if not tens of thousands, if not hundreds of thousands of pages of information, as well as other evidence that's there, there's a process by which we have to go in front of the judge to ask her permission in order to present it to you. So and that is not something that can happen by Friday. So by definition, the representative is not in the position to present to you the information that will exonerate him because there just isn't time. So again, to the extent that the process is supposed to be fair and deliberate, that fairness and deliberateness cannot take place by Friday. Among other reasons, because the judge does not entertain such motions every day. Among other reasons, because based on the amount of information that has been provided, including information many of you have heard on the con man who's at the center of this investigation, that has not all been provided. So there's a lot of information that just by definition, again, if the process is going to be fair and deliberate, cannot be done by Friday.
Is there a response from the House managers?
My response, Madam Chairman, would be the same. Whatever is going on in the federal district court is of interest to the taxpayers, is of interest to the federal prosecutor, but the House must maintain the House's integrity. And this matter has been underway for some time, since the time Representative Smith was arrested. And I believe that Mr. Henderson and Representative Smith have had ample time to request specific items of the federal government. Now, it may be that they've just received some information, but neither the election nor the federal prosecution should hold up the proceeding of the House of Representatives to determine whether there's a member among us who has A, either violated the law, or B, violated his public trust.
Questions of the committee. Representative Riley.
Thank you, Madam Chair. And this question, well, goes to all of you, essentially, the House managers and Mr. Henderson. We're sort of having a little bone of contention here with regard to scheduling, and it has to do with the information under the protective order and some other kinds of considerations. I'd like a little clarification, and maybe this is part of sort of a rhetorical question. These issues and this information was not part of what the Special Investigative Committee was privy to. Isn't that correct?
I'd like to respond to that. The Special Investigating Committee has seen nothing other than the allegations that were advanced by the prosecutor. So other than, again, the allegations or the complaint, there has been no evidence bearing on this matter that anyone has seen. The government just turned it over to us, meaning the lawyers for Mr. Smith, within the past 24 to 48 hours.
Well, this is true, and this is my point. And a lot of what we are dealing with are the information that the Special Investigative Committee had and the decisions that they made. So isn't it that some of these kinds of issues, like the protective order, isn't that something that really is more important to the impending federal trial and not necessarily what we're here to do?
Again, I'd like to respond. I think the answer to that is no. There's a procedural aspect of this proceeding, and then there's a substantive aspect. You know, and I think the analogy is, would any of us want to have a school teacher give us our grade before they even look at the test? Or would any of us want to lose our jobs because we are accused of wrongdoing without having our employer do an investigation? As of this point in time, the body doesn't have any information. All you have is an allegation and a charge. And so when you talk about it protecting the integrity of the House, and I would like to make a side comment, I had the privilege of serving as staff counsel for the United States House of Representatives Ethics Committee in Washington, D.C. And so it's not just about the outcome, it's about the process. And so if all of us who've been to school, if you're comfortable with your teacher giving you a grade without looking at the test, people are not going to be comfortable with the grade. All of us could relate to that. Or even in a very clearer terms, if any of us were charged with wrongdoing at our jobs and our employer just said, well, you're out, without hearing what you have to say or without looking at the evidence, we'd all be concerned about, we wouldn't buy into the outcome because the process is flawed. And what I'm representing to you as of this point in time, you have no information.
Well, that's a nice analogy, but this is a special body, we here in the House. And so I'm not so sure that, you know, that really rises to what our responsibilities are. I mean, I suppose we could say we had enough because we have the information that came from the Special Investigative Committee, and that's all that we had at the time. I'd like to, is there an opinion from the House managers on my point?
I think...
Representative Lang.
Thank you. I think your point, Mr. Riley, is well taken. The fact is that because the House rules require that actual evidence in this matter be presented under the rules of criminal evidence, much of what Mr. Henderson may have received, and I don't know what it is, may not be admissible here at all. For instance, the federal agent who signed the affidavit that was attached to the federal complaint is not going to be made available to this committee by the U.S. Attorney, and therefore he can't be cross-examined. The confidential informant is not going to be made available to this committee, so that person cannot be cross-examined. Many of the documents cannot be properly, a foundation cannot be properly laid under the rules of criminal procedure, so those documents will not be admissible into evidence. And so my guess is that much of what Mr. Henderson is referring to may be helpful to him in the criminal case, but under our rules and under the rules we're using, would most likely not be entered into evidence in this proceeding.
Thank you. Have you finished? Yes. I guess I have a real quick question for Mr. Henderson. One way in which we might be able to hear the other side of the story would be that if your client would be prepared to testify before this committee, do you have any plan to bring him before us?
There is a plan to bring him before the body. However, that we would not make that final determination until we have had an opportunity to review all of the information. You know, for example, and again, I don't need to remind all of you about some things you know, but this government, for example, brought charges against Roger Clemens just a week or two ago, and he was exonerated. This same government brought charges against former presidential candidate John Edwards. He was exonerated. What I'm encouraging you to do is to allow the process to play itself out and to get the information and then make a decision, as opposed to make a decision and then get the evidence. And that's the sum and substance, and so that getting the evidence is a process that has just started, and you can go on record and see that Representative Smith asked for all of the information to be released to this body. The judge denied that request. The government, conversely, not only did it deny this body's request or the request from the Special Investigating Committee to get all the information, so you all asked for the information as well, your request was denied. So it would be different. I think that the body should look at this proceeding differently if Representative Smith was the one who was trying to hide the information or to try to keep the information secret or to try to keep the information from you. No, conversely, Representative Smith is the one who has asked for all of the information to come out so the body can have access to it. You have asked for it and you have been denied it.
We appreciate that, but let me just point out that we have adopted a motion that says that we are not prepared to use this committee to interfere with the ongoing criminal investigation before the United States Attorney. And I appreciate your point that it was Representative Smith that wanted all this information to be available. I would just reiterate the point that if Mr. Smith wants to come before this committee, he had every opportunity to appear today and tell his side of the story. Representative Greg Harris.
Thank you, Madam Chairman. And this is a question to Mr. Henderson here. I'm not an attorney, so if I ask sort of silly legal questions, please bear with me and you'll have to help enlighten me on this. So I'm looking at the Judge Coleman's protective order regarding discovery here that we've been provided, and I assume this is the order that you're referring to that allowed you to have access to certain documents that you say you got in the last couple of days.
Yes.
Okay, so that order was entered 2 weeks ago.
I don't know that it was 2 weeks ago, but relatively recently.
Yeah, the 14th of June is what the order says. So you got some documents. We don't know whether it's 100 pages or 500 pages or 1,000 pages. You know, obviously, that if you read the order, that information is made available to you and only to you. In using your analogy about, you have to, take a test and you have to study before you take the test. At some point, you do have to take the test. So how long would you need to study? I mean, given the volume of documents you've used the election, which I don't think is relevant to our particular inquiry as an endpoint. But from your point of view, just looking at the actual number of documents, how long will it take you to read through those, study them, and formulate a response?
I don't know the full universe of documents as of this point in time because, again, we just got them 12 to 24 hours ago. We've sent them to a IT company to help us access them. So we're in the process now trying to access the information to find out how much there is. So I don't know right now how much there is, and so therefore I can't tell you how long it will take us. I mean, I should be able to give you an answer to that in a week or two. As soon as the IT people get back to us, but I can't give you that information right now.
So you don't even know how many documents you have?
We've got disks, and the disks we have computer disks, and the disks contain documents. So we have IT people who will take, 20 or 30 or 40 disks and let us know how much evidence or how much information is stored on those disks.
Yeah, thank you.
And I would also like to refute an earlier point, or at least clarify an earlier point. The statement has been made on more than one occasion that Representative Smith has had an opportunity to come and tell his side of the story. I don't think that's quite accurate. In this preamble and in the document, you indicate that the representative has a constitutional right, and you acknowledge that he has a constitutional right to remain silent. And so to suggest or imply that by exercising his constitutional rights that are guaranteed to all of us, and that his failure to discuss with this body thus far means that he has not taken advantage of an opportunity to speak, I think, is not completely accurate. Because if that's the case, then the right that the Constitution guarantees all of us becomes meaningless. And what we have indicated is that the representative would like an opportunity to review all of the information and then be able to present facts and evidence to you in a process that you earlier said was going to be fair and deliberate. And so he'd like that opportunity.
And let me make that, since I was the one who mentioned that, I was in no way suggesting that he should not exercise his right, as you point out, that he has under the Constitution to remain silent. I was only trying in a shorthand kind of way to say that if you and he want the other side of the story to be available to this committee, that would have been one avenue. Mr. Durkin.
Thank you, Madam Chair. I think we're getting a little bit off track. Let's be very clear about this. This committee is not here to determine whether or not Representative Derrick Smith is guilty of a federal crime. You're here as an internal function of the House of Representatives to determine whether or not he's impugned the integrity of the House. So I think that Representative Lang and I will, in short order, have our case and our documents prepared within the next 2 days. There will be no secrets. We are not going to try this hearing or trial by ambush, and most of the information which we will proceed with are already in the public domain. And I would suggest that if there is a defense, it can only come from the mouth of one person. And I would ask that he present his case. We can go through months of document review by the U.S. Attorney's Office. It really does have no relevance to what we are here to determine today and also sometime down the road. I also will just make this comment that if counsel is dissatisfied with Judge Coleman's protective order, I'd like to know whether or not he intends to file a notice of appeal and take that up to the appellate court. And secondly, I just want to add, even though this government was responsible for trying Roger Clemens and also John Edwards, this government also was responsible for trying Rob Blagojevich about a year ago.
Thank you, Mr. Durkin. Are there further questions, comments from members of the committee?
I have one additional, if
Representative
I may,
Lang.
Madam Chairman. You've alluded to this in your comments, but I want to make sure this is part of the record, that I would make a formal request of Mr. Henderson to present his client before this committee and before the House managers for our questioning.
Thank you. Further comments or questions? Representative Rose.
Mr. Henderson, do you have a response to Representative Durkin's question about the whether you intend to file an appeal of the protective order or not?
We're still looking at the protective order. However, as a general rule, the protective order deals with issues of discovery. It would be highly unlikely that an appellate court would reverse a decision of a district court judge in the context of discovery, and that's even before we make a determination that we're dissatisfied with the protective order, which we have not done. I mean, some of this delves into legal strategy of the representatives, which I don't want to disclose, but I'm fairly comfortable that we'll be able to get access to the information that we want to get access to present before this body. The only issue is timing. So I'm not, my issue is not with the protective order, rather the issue, again, is with the speed within which these proceedings appear to be going, which undermines, at least from the representative's standpoint, and again, I have to speak on his behalf, the representation that the proceeding was going to be fair and that the proceeding was also going to take into account evidence. I'd also like to make one response to what Mr. Durkin said. I think from our perspective, and again, as it relates to the reputation of the House, because I recognize that this proceeding does not take place in the context of a federal criminal trial. Rather, it's about protecting the reputation and institution of this House as a body. And so I don't think it's just about Representative Smith. I think it's also about the process and whether people will perceive that it was fair. Because I think that's the much greater issue, is Representative Smith is the person that brings us here today. However, the process and democracy is much bigger than Representative Smith, and so all eyes will be watching as to whether or not people perceive that the process has been fair and whether or not the body has reviewed evidence, because I think the reputation of the House will linger far longer than this issue with Representative Smith. He just happens to be the one who's here today.
Are there any further questions or comments from the managers or from members of the committee? If not, a reminder that the issue before us is the issue of a schedule. And I will take the matter of scheduling under advisement, and I plan to release a schedule soon, possibly as soon as the end of this week, possibly even earlier. And if there's nothing further to come before the committee, I'd remind Mr. Henderson and the House managers that if you have any questions or need any additional information, please feel free to talk to our counsel, David Ellis. And I want to remind all of you that you're not allowed to talk to us, the members of the committee. And, all right, Representative Rose.
I do have one last thing, and really it's just to thank Mr. Ellis and Mr. Freiheit, our staff attorneys on both sides, as well as all the staff that have put in countless hours. I know I was reading emails sent at 3:43 a.m. the other morning. So while we're all here, we want to say a very appreciative thanks to the staff as well.
And I will second that motion. So with no further business to come before the committee, the Select Committee on Discipline will recess to the call of the chair. Thank you all very much.